SJC-12188, Commonwealth v. Sean A. Baldwin.
Ms. Renaud, get yourself organized, and then you can begin. Take your time, take your time, take your time.
Hopefully I can talk
We
without
understand that
coughing.
cough. I had the same one. Go ahead.
Hey, may it please the court, good morning. My name is Suzanne Renaud. I'm representing Sean Baldwin. Your Honors, Mr. Baldwin is asking you to vacate the allowance of the 211 Section 3 petition that was granted by Judge Botsford sitting as a single justice in the county court. And the primary, or rather the first reason for this, that he is appealing that decision is based on the fact that obviously, Your Honors know that you have discretion in allowing these petitions, but that discretion is cabined by the case law that has come before. And in this case, we have a clear case precedent that is controlling. Obviously, there might be some exceptions to it, but it is controlling up to a certain point, and that's Commonwealth versus Yelly. And Yelly basically says, from 1983, and it's been repeated several times, that when the issue deals with erroneously admitted evidence, or in this case, evidence that was not allowed to be admitted, when we're dealing with the rules of evidence themselves, that is not the type of extraordinary matter that warrants consideration under Chapter 211, Section 3. That to go and evaluate any time that one of the parties, the defendant, the Commonwealth, gets an adverse evidentiary ruling would basically be too much oversight of the trial court, and it would be something that the parties would come in and just basically be complaining when those kinds of cases, these evidentiary rulings, turn on their specific facts.
So are you saying it was an abuse of discretion by Justice Botsford to have decided this case on the merits?
I do, Your Honor.
That if she decided on the merits and decided that the judge below was right, that would have been okay with you?
If she had decided the judge below was right, I think it still would have been an abuse of discretion, but it wouldn't have been
Just
one
the
that...
consideration of it alone was the abuse of discretion.
The consideration itself
Even if, so you're saying Yelly is an absolute law, is an absolute rule that a single justice does not have the discretion to determine that in these particular circumstances, notwithstanding that it is extraordinary?
Your Honor, I don't think that Yelly is as categorical as that, and I want to be sure. Yelly actually, and maybe as Hernandez has interpreted Yelly more recently, it says, normally these cases are fact-specific, but if it were to be found that there was some kind of wide-ranging impact beyond the case, or that the Commonwealth itself could show that it was prevented from fairly prosecuting a case, that would be something rather extraordinary. The Commonwealth here in its initial petition notably didn't put anything in factually about why this case was extraordinary to that degree. And even in the brief that it submitted before Your Honors, the reasons that it's giving they're not showing that the motion judge below fairly denied it the ability to try to bring the case. That Yelly actually addressed this. They said just because it's more difficult to try a case doesn't mean that that's an unfair burden. That's just the result of applying a rule of evidence. So there would have to be something more. But in this case, the Commonwealth isn't even precluded from bringing the type of evidence it wants to bring. It's been foreclosed on saying that it can just rely on hearsay evidence, but there is nothing that the judge has done up to this point that says that it can't call a witness or can't call the alleged victim to prove its case. And so to say it's denied a fair trial, that particular exception that would enunciated in Hernandez wouldn't apply. And to say that also there's a far-ranging impact beyond this case Yes, it might be that there are hearsay issues that come up in domestic violence cases, but they come up in murder cases, they come up in rape cases, they come up in all sorts of cases. The fact that there are evidentiary rules dealing with hearsay is because these are very common kinds of cases. And
If I can move you to the substance.
Yes, Your Honor.
Because I think we are likely to reach that issue.
Yes, Your Honor.
With regard to the evidentiary hearing, did the judge hear only the 911 tape, or was evidence taken?
The only evidence that was taken was at sidebar, and then she repeated it, was that she asked whether the police officer had opportunities to see the child, and I believe that she read the police report as well. And I know in the Commonwealth petition it attached the police report.
So the only evidence before the motion judge was the police report and the 911.
That is correct, Your Honor.
Does that mean then that the single justice, upon her review, if she was permitted to do that substantive review, was in the same position as the motion judge to decide it?
She was in the same position, and when she decided the facts, the single justice decided the facts, it doesn't appear that she took any issue with the facts as decided by the motion judge. In fact, she just repeated the record and didn't critique them, criticize them, or otherwise.
So she, under our case law, is permitted to do essentially a de novo review because she's looking at the very same thing that the judge below was looking at?
Your Honor, I would say that when it comes to looking at the facts, I mean, because this is being reviewed for abuse of discretion, it wouldn't be a complete de novo review of the facts themselves. It would be whether or not the judge abused her discretion when finding facts. So that, I don't believe it would be de novo review, and she did not engage in a de novo review. Now, if Your Honors would, I would say that that means that at this point, it looks like the facts as found by the motion judge and approved by the single justice are the facts that are the universe of facts that we're dealing with. Your Honors obviously could find that there's something critically wrong or abuse of discretion in the findings of those facts, but at this point, those are the facts. And there were, with the one exception that Mr. Baldwin has identified, which is that it appears that the single justice missed part of the discussion at the end of the hearing dealing with Crawford. So there was some additional discussion. There were no additional facts that necessarily came out in that discussion, but there was some additional legal analysis that occurred at the end of the hearing. So within this universe of facts, I mean, those become very, very important because you can't necessarily rely on the facts as the Commonwealth has been urging that they be found. Now, that's an alternative that might have been found, but it isn't the one that was actually found by either of these two judges. So the key thing here is that the motion judge said, this child appeared calm. So we're dealing with that. The key thing here is that nobody observed the child. So we have that as a fact. And then the third and perhaps most important one was that she said basically that the 911 tape was not self-authenticating in any way, that she couldn't tell what was happening. She couldn't tell if the stressing event was ongoing. She couldn't tell, just because the child used the word just, and it's not that she missed that fact, but she couldn't tell if whatever background noise that she was hearing was a continuation of the original allegedly exciting event, which is very, very important because when you're dealing with the hearsay issue, one of the critical factors to be considering is the excitement ongoing? Or, and I think because she identified those key pieces of information, it means that she was following the law. She wasn't simply determining that this child was calm. She was looking for some kind of corroboration as well. She was looking to see if it was corroborated by what was happening on that 911 tape. And she said, I can't determine that. She was looking to see if there was somebody a witness who could come after the fact and say, what did the child appear like? What was the child's demeanor? How was the child acting when you observed him? Well, that wasn't on this record either. And so those were the facts that, maybe she could have articulated them, the motion judge, a little bit better. But those facts were there. So when the single justice reduced her findings and said, I think all she's doing is looking at the child's demeanor, I don't think that that's supported by the record. And if you go on to the end of the hearing where she's talking about Crawford, which specifically is asking, is this child who maybe is late reporting, is this child still under some kind of stressing event? you can see that the motion judge is reinforcing and reiterating the fact that she does not believe that the stressing event was something that she could conclude. The one last thing, Your Honor, obviously we're asking that you vacate the single justice's order. I would just like to mention for the record that this issue about confrontation clause is something that if you adopt the way that the relief that the Commonwealth said was set, it creates a problem that confrontation clause rights of Mr. Baldwin will never have been evaluated by any court. So if he were convicted on the basis of this 911 statement, he would immediately have an appealable issue. So I believe that the confrontation clause issue has to be addressed in some way, and I would just like to mention that for the record. But we are asking that this petition be vacated and the motion judge's decision be reinstated. And with that, I'll rest on my briefs. Thank you.
Mr. DeRosa, welcome.
Good morning. May it please the court, Ron DeRosa on behalf of the Commonwealth. If I could just pick up just briefly where my sister left off, I agree that the confrontation clause issue would need to be addressed by the trial judge in the first instance. She did not reach it here because she found that the spontaneous utterance exception wasn't met. So I agree that should this court uphold affirm Justice Botsford's order, it would need to be, the motion in limine would need to be remanded for the defendant's challenge based on the confrontation clause as well. But in any event, I would ask that this court affirm the single justice's, or Justice Botsford's order allowing the Commonwealth's motion in limine. I think there was no abuse of discretion here when she found that the district court judge essentially misapplied the law of spontaneous utterance when she excluded the statement. I think that can be seen directly from the transcript where after the Commonwealth and the defendant make their argument, she takes it under advisement, goes back to consider some cases. The case she considered and the case she found controlling, which I think probably needed some correction because she said she'd even relied on it before when excluding spontaneous utterance, statements as spontaneous utterance in other cases, was Commonwealth versus Tang from the appeals court, which Justice Lenk authored when she was still on the appeals court. Spontaneous utterance, that exception was not before that court in that case. It was a confrontation clause analysis that the court did in the first part of the opinion, then the issue of competency of the declarant. So essentially we have a judge relying on a case that doesn't apply in order to exclude this statement. I would also say that when the judge excluded the statement, she did so only considering the tone of the 6-year-old boy's statement and the tone of the 6-year-old boy's voice on the recording. I don't know if this court's had the chance to listen to the 911 call here. He does sound, and he's not frantic in the call. I would say there's a sense of urgency in his voice. He says, "My dad just choked my mom." So obviously he's still under the sway of the event, and if the court needed any, or as Justice Botsford found when because she herself specifically noted she had listened to the tape, there's the defendant, I think it's a reasonable inference, yelling at the boy's mother in the background of it. So I think Justice Botsford's decision was certainly not an abuse of discretion when she found that the district court judge committed an error when she denied the Commonwealth's motion in limine to admit the statement as a spontaneous utterance.
Justice Botsford considering the spontaneous utterance issue de novo?
I believe she was, Your Honor, under an abuse of discretion standard. She had everything, as Justice Gantz pointed out, she had everything before her that the district court judge had. The Commonwealth had played the 911 tape before the district court judge.
So what we have then, if that's right, what we're looking at is whether Justice Botsford, in listening to this tape where the 6-year-old boy is commenting on what's happening or just happening to her daughter, whether Justice Botsford abused her discretion in determining that that constituted a spontaneous utterance.
Yes, I believe that would be the standard of review, but I also think that Justice Botsford found that, and if you read her memorandum of decision, that the judge misapplied the law of spontaneous utterance because she considered only the tone of the boy's voice rather than the totality of the circumstances surrounding the boy's statement when he made it, in determining whether he made the spontaneous utterance. So I'd suggest her decision was that the judge made an error of law, essentially, and that led to the abuse of discretion because she didn't consider everything she should have when finding that the statement was not admissible as a spontaneous utterance.
So am I correct that your position is that if you prevail and we affirm Justice Botsford's order, it does not necessarily mean that the 911 call would be admitted? It still has to pass the hurdle of the confrontation
She did not
clause.
decide the confrontation clause issue.
And I gather no one yet has made any claim that the 6-year-old is incompetent.
He did, actually, there was, Your Honor. There was a competency.
Claim of incompetency?
There wasn't much discussion below at the motion to eliminate hearing, but he did suggest that he would be challenging the competency of the boy should he be called to testify.
But that was not decided by Justice Botsford.
That was not decided. It was spontaneous.
Back to the trial court judge.
Yes, the only issue that the trial court justice started with spontaneous utterance, and on that basis, she excluded the statement.
Going back to Justice Lowy's question, generally, when we review a trial judge's findings, it's for abuse of discretion. Here, she had the same information before her as the trial judge, and arguably, maybe, it was appropriate for it to be de novo. We now have the same things before us that Justice Botsford had before her. Is our review of her abuse of discretion, or is our review itself de novo?
I think under this case's practice, it would be an abuse of discretion. It can look at the facts de novo in the sense that the facts are, there was no factual finding really that was made by the district court judge or Justice Botsford that's entitled to deference because you have the recording, you can listen to it. But I do think when you're reviewing her ruling and her analysis, it looks at it under the LL standard of abuse of discretion, whether there was a clear error of judgment. Which I think why Judge Botsford found that there was, because she found the district court judge had misapplied the law of spontaneous utterance, which is why I think it's well supported and is not why Justice Botsford's ruling was not an abuse of discretion. Happy to answer more questions. I would ask you to affirm the single justice ruling. Thank you.